I wanted to go back and look at some video of you in 1987 testifying before the United States Senate Judiciary Committee about Robert Bork.
Gradually but steadily over the past 35 years, more and more decisions have been taken out of the hands of the American people and vested in courts. Those preoccupied with the merits or demerits of the specific issues raised in the cases involved pay little attention to the general drift away from accountable representative government. The ad hoc way many of these landmark cases of this era were based on legal principles improvised for the moment has meant that law itself has become more and more a matter of how judges happen to feel politically or socially about particular issues or particular litigants. No one has opposed these judicial trends more consistently or more ably than Robert H. Bork, first as a scholar and then as a judge. Mr. Bork has rejected the idea that judges should engage in heroic adventures in policymaking, as he calls it. The renunciation of power, he has said, is the morality of the jurist, not the assumption of power in the name of morality. What Mr. Bork has fought against consistently over the years has been, in his words, government by judges who are not applying the Constitution. Against this background of historic issues about the very meaning of law, it is both ironic and appalling that Judge Bork's own record is being judged on a myopic basis of an issue-by-issue statistical box score on how he has allegedly voted for or against one class of litigants or another, as if he liked chemical companies more than he liked pregnant women, or liked asbestos manufacturers better than he liked bereaved widows. Surely no responsible person thinks that this is what law is all about. Yet such shrill propaganda from special interest groups is repeated in respectable quarters as if the statistics represented some objective fact. Many people have no idea how utterly worthless and therefore deceptive such statistical box scores can be. Last year this time in California, there was a bitter election campaign over the re-election of the state Chief Justice. During that campaign, one side cited statistics to show that the Chief Justice had voted for defendants 85% of the time over a period of nearly a decade. The other side, using exactly the same raw statistical data for exactly the same span of years, concluded that the Chief Justice had voted for the prosecution nearly 90% of the time. Well, these are not small differences, either in terms of numbers or implications. Neither were they based on any esoteric statistical methods. All that they depended upon were differences in definition as to what was a vote for the prosecution.
Let me ask you a couple questions. You think judicial activism, Doctor, has hurt blacks. Judicial activism of eliminating restrictive covenants in deeds, eliminating segregation in schools, one man, one vote, literacy test. Do you consider those judicially active?
Well, as regards restrictive covenants, I can see no evidence that they did anything other than make some people feel good because it was symbolic. As regards desegregation of the school system, that should have been done long before and on a much more sound basis. I've gone into this at great length in previous writings.
But are they...
You see, the problem is not whether you believe that school desegregation should have ended. I believe it should have ended long before.
Right.
Judge Bork believes it should have ended long before. What he and what I have objected to are the principles used in that decision, because those principles take on a life of their own, and they come back to haunt you in other areas. Obviously, this old phrase, hard cases make bad law, derived from that fact. You dream up a principle to reach this result, and then the principle has a life of its own.
So the principle of desegregating the schools...
No, that wasn't the principle. The principle was the reason that they picked for it. Well,
that's all I'm saying. Okay, the reasons they picked...
Yes.
Desegregating the schools, you and Judge Bork agree were the wrong principles, and they should have not. So the court shouldn't have done that.
No, the court should have done it.
Oh, okay.
Both of us have said the court should have done it.
I see.
And in my case, and I think in his case, the court should have done it a lot sooner.
How?
They They should have ruled that it wasn't equal protection of the law, because nobody in his right mind believes that there was equal protection of the law in the Jim Crow era of these school systems.
I'm just trying to figure out what you're saying.
Yeah.
Well, how about literacy test? Was it judicial?
I see no reason why people shouldn't be literate in order to vote. The question is, if you have a black who comes in with his degree from Harvard, and the man behind the desk says, no, you're not literate, you can't vote, then this is what bothers me. People are talking about how judges should be sensitive to this particular group or that particular group. And if that means anything, if it means he's applying the law differently, that's precisely how blacks were held down for generations in the South.
So
by
literacy
applying the law differently.
So literacy test, as long as they were equally applied, are all right.
Sure.
So I thought you thought. You believe there are not enough black women and men out there that are the same as white women and men to be able to go through Harvard and MIT.
If there were, it would mean that the whole history of oppression had done no harm whatever.
Well, so the answer is you don't think there are. I just want to figure out what you're saying.
It's not a question of what I think, it's a factual matter.
So factually, you're saying factually there are not enough.
Factually, this study's already been done by Clickguard at Harvard, and the figures are all there. Anyone can look them up.
Okay, no, I just want to hear from you. I want to know what you're thinking. Have you read all of Judge Bork's cases, or any of them? Have you read all of his writings?
I haven't read all of them, but I've been reading them for more than 20 years because I used to teach antitrust economics.
Now, are you part of what they call the law and economics school? You know that. Would you consider yourself part of that school? There's nothing wrong with that. It's not a bad school. I just wanted to know where you are.
When I sit down to write, Senator, I don't ask what my label. I don't check my identification tag to see what I am. But I did. One of my books did win a prize as the best book in law and economics in 1980.
Why did you testify there, and what impact did the rejection of Robert Bork have on the rest of the judiciary over the years?
I testified because of the gross distortions that were coming out. I was listening to the congressional hearings during the day, and I'd hear how Bork was, at the very least, racially insensitive, or actually opposed to civil rights and so forth. And then I would go over to the Stanford Law Library and check out Judge Bork's record, and his record before he became a judge. And I discovered in those files amicus curiae papers filed by Judge Bork repeatedly on the side of black civil rights organization. I learned that no civil rights advocate had ever lost a case in Judge Bork's court. And I was already familiar with Bork's record before I even looked into the law, because I was teaching economics, and I often read things that he wrote about antitrust law, which were brilliant things. And so an enormously intelligent man, an enormously decent man, and all sorts of utter filth was brought up. One being, for example, that he worked for big corporations, you see, because money was more important to him. And Bork was an academic, which is not a big bucks enterprise to get rich quick, and a government official, of which the same could be said. And at the particular time he went to work at a high salary in business, his wife was dying of cancer, and he wanted to have the money to make her last days as comfortable as he possibly could. And for that to be turned into some kind of cheap political charge was just truly despicable. More than that, the difference of one man on a Supreme Court that's divided is enormous. And every time I read an opinion by Justice Anthony Kennedy that is wishy-washy and incoherent in some cases, I think that's the price of defeating Judge Bork. So, because he was sent in to replace him.
What else is your take on the Supreme Court today, just as an institution after all these years?
Oh, it's very dicey, and what's dicey are the freedoms that depend upon whether the courts enforce the Constitution or whether they go off on their own social adventures. I think the greatest disappointment with this court was Chief Justice Roberts disregarding the 10th Amendment and finding some terribly clever way of evading it and declaring Obamacare constitutional. You know, the 10th Amendment says that the government has only such powers that are specific, the federal government has only such powers as are specifically designated to it, and all other powers either belong to state governments or belong to the people themselves. There is no power for the federal government to tell people what kind of medical insurance they have to buy, even if they prefer something else. But because I have no idea what terribly clever reasons the Chief Justice might have had, but once you knock down the 10th Amendment, there's really nothing the government can't order us to do.